Mr. Moore, are you here on the arraignment too?
For Walsh, I can handle whatever you need.
Okay. So this is in the matter of the people of the state of Michigan versus William Badger, file number 2021-20463FH. I have Douglas Hartung appearing on behalf of the people and Patrick O'Keefe appearing on behalf of the defendant. The defendant is requested to be in person and he is present in the courtroom. This is a date and time set for sentencing in this matter. I have received the defendant's sentencing memorandum as ordered and have had an opportunity to review that. Mr. Hartung, I have not received one from the people because we did receive this one late. Were you willing to proceed verbally today on the record, or do you wish an opportunity to file a written response?
I'm willing to go forward today, Your Honor. And also, I believe there's one individual going to zoom in for this.
So they are not zoomed in. I have a note for them, but they have not zoomed in because I have.
They're gonna keep trying, I guess.
Okay.
Thank you.
Okay. If I do have a note about their names, so if they pop in, I'll let them in right away. Okay. All right. So, Mr. Badger, this is the date and time set for sentencing. Have you had an opportunity to read and review the pre-sentence report? Either this time or the last time?
Yes, Your Honor.
Okay, and have you had an opportunity to discuss that report with your attorney? I know you discussed it last time, and I know he spoke with you this morning. So have you had ample time to discuss that with your attorney?
Yes, Your Honor.
All right, are you satisfied with Mr. Badger or Mr. O'Keefe as your attorney and the advice that?
No, Your Honor, I feel like it was excuse me. I wasn't represented properly. I think we covered, there were some things that were covered and some things that weren't covered because of evidence. We didn't present our evidence, nor did we present witnesses that could collaborate some of the evidence that the prosecution had.
Okay.
So I just don't feel like he did a full, he did some, but it just doesn't feel like he did a full represented me. I'm trying to think of the legal term, but I can't at this moment. I just don't feel like I was properly represented.
Okay. And but during the trial, you sat with your attorney. He met with you quite often. Like met with you daily during the trial.
Yes, Your Honor.
And then you discussed strategies with him.
I didn't have any idea what direction we were going with this, Your Honor. Really, we started out with a strong avenue of what we're talking about in the beginning, and we said we had a case, you know, and even when the offer was laid on the table for me taking a plea deal, he was like, we have a case. He goes, we've got a case. So never being in trouble, I look back on it going, I referred to him like, I looked at it like, well, if we got something, then I'm willing to go that direction. So I have no idea. So I listened to what my counsel had to say. I paid him in full of what was supposed to be done, and this is where we're at today.
Well, yeah, you were convicted by a jury.
Yes,
all right, Mr. Hartung, is there any response to that statement? I'll allow Mr. O'Keefe to speak as well.
Okay. Well, first of all, 94 days ago, this was all fine. We were good that day. He said everything that Mr. O'Keefe did was perfect for him. It was fine. He was well represented. Mr. O'Keefe did an outstanding job representing this defendant. He started, and every time we had a pretrial, we put on the record he had an opportunity to plead to this particular plea bargain. And every single time he decided he didn't want to do that. Even right before the trial began, that was all placed on the record. He said he didn't want to do it. During the course of the trial, he and Mr. O'Keefe met and talked, and they made a decision that they placed on the record that he did not want to testify. And he was comfortable with that, and he made that decision that day, or probably prior to that day, to put the information on the record that day. There's absolutely no basis whatsoever. Mr. O'Keefe did an outstanding job.
Mr. O'Keefe, do you wish to respond?
Briefly, Your Honor, this is the first I've heard this from my client, and I'm not going to stand here and attempt to defend myself because I'm confident that I represented him to the best of my abilities. I'm confident that I was effective as his attorney, given that this is new territory for me. This is the first time I've heard my client say anything about my being ineffective. Now, he has expressed some buyer's remorse about the trial and about the verdict, and that sounds like that's what we're dealing with here. But if it's something that's more technical than that, I'm questioning whether I should go forward as his attorney. If he doesn't have confidence in me now, I can't imagine that he would have confidence in me going forward with the sentencing.
Well, what I would say on the record is that I always very studiously put plea agreements on the record and ramifications of plea agreements, almost ad nauseum, because I was a former defense attorney and I know that people sometimes do not understand the ramifications of a conviction or a plea. So I think that you knowingly went into a trial knowing what the plea offer was. Both attorneys, Mr. Hartung and Mr. O'Keefe, were exceptionally prepared and studious during this trial. And so, Mr. Badger, your proposed dissatisfaction with your attorney is something you would deal with on appeal. So, Mr. Badger, do you want to proceed to sentencing with Mr. O'Keefe today and let him argue his sentencing memorandum?
I feel confident in his arguments, Your Honor. I just don't feel confident that in the trial, during the trial, the things that were needed to become out, my witnesses, we didn't pull the witnesses.
Okay, well, that's,
Sorry. Yes, Your Honor. I wish for him to allow to move forward.
okay. So, Mr. O'Keefe, you provided to the court a sentencing memorandum that went into great length, your request regarding the sentencing guidelines. So I'm not going to start with that first. So the first thing I would ask, Mr. Badger, as I said, you read the pre-sentence report, correct?
We went over it together,
Yes.
the lawyer and I, yes.
All right. Do you wish to explain or challenge the accuracy or relevancy of any information in that report regarding your family, your background, your history, your medical history, financial history?
No, Your Honor, the financial history was, everything got paid off through the.
No, I'm just saying, is
No.
the document, was the information about your background correct?
Yes,
Okay. Now, I understand there is a statement taken from the police report in that pre-sentence report detailing the incident as reported in the police report. And you may agree or disagree with some of that. But in terms of any other information in the report, do you wish to explain or challenge that?
I didn't quite understand what you're saying, Your
Okay,
Honor.
so you read the pre-sentence report, right?
Yes,
Okay, and in that pre-sentence report, there's an evaluation and plan that talks about you, additional information. No?
No.
I have a Haley Toms in jail room 6.
Okay, thank you.
Do you want my Zoom number again?
I resent it.
Okay. He may be connecting, he's just not popped into my waiting room yet. So in that report, there's a victim impact statement. There is a summary of the police report, your lack of prior record, family information, marriage information, employment, education, substance abuse, health, and finance. So Mr. O'Keefe, I know that you had an opportunity to speak with him about that. Do you wish to explain or challenge the accuracy or relevancy of any of that information?
Well, there's just a couple of factual corrections, Your Honor. On page 9 of the PSR, it indicates that Mr. Badger has an asset in his house worth $135,000. I'm not sure if this matters to the Department of Corrections, which is why I raise it now. Mr. Badger's informed me that he sold that home. Is that correct, sir?
you're correct.
And then beneath that, with respect to his liabilities, it indicates a mortgage of $59,000. And I believe that mortgage has been discharged through the sale of the house.
Okay.
Is that correct, Mr. Badger?
You're correct.
All right. So aside from that, Your Honor, we don't have any.
So, Mr. Moore, can we just add a sentence that at the time of sentencing, this debt was discharged and the home was sold?
Yes, I was going to add, Your Honor, just to remind the court, when we were in here last time, I did make a change to his medical to March 2021, which will reflect it in his information with the Department of Corrections. And also, I thought, so the home sold for $147,000 on April 4th, and I thought I would put that in as a sentence below because at the time of the PSI, he did own the home and have the mortgage. So I can add that sentence on there.
Okay. And Mr. Moore was referencing under health, the last time we were here, you had made a correction. Treatment date was not 2024 on those two issues. It was 2021, and that's been marked.
Correct. Thank you, Your Honor.
Okay. And he has no prior convictions, really. So now we move on to your sentencing memorandum.
Your Honor, we have an issue with the jail credit as well.
Yeah, we'll update that too.
Okay.
Yeah. What's the updated jail credit now, Mr. Moore?
Go ahead. I'll get that figured out real quick.
It's 94 additional days.
94 additional days.
Okay.
So.
So
170, so we'll make that 170 days. Thank you, Mr. O'Keefe. All right, so let's move on to the sentencing memorandum. So Mr. O'Keefe, you may proceed on that.
thanks, Your Honor, and I apologize to the court and to the people for the late submission. This snuck up on me, so I apologize. I should have had this on my calendar to submit sooner to give Mr. Hartime an opportunity to respond. But nonetheless, I felt it was important to at least place the objections in writing and make them part of the record before we proceed to sentencing. The defendant has an objection to scoring a PRV 7, as was indicated in the sentencing memorandum. Without going into a whole lot of detail, I know the court's read the memorandum. We would object to scoring PRV 7 at 10 points. I realize that the court is more or less constrained to score the highest number of points. However, I wanted to place on the record a constitutional challenge rather than a discretionary challenge. I know the court doesn't have discretion, but you know, it's always struck me as a little bit odd when you have an incident that involves two separate offenses that's part of the same series of conduct, that you could score that as part of a person's prior record. You know, we deal with PRVs a lot in this business, and the word prior is antithetical to what is indicated in PRV 7, which is subsequent or concurrent felony convictions. So I'm not asking the court to make a discretionary change in that guideline, but I do want to make a constitutional challenge on the grounds that would be considered extra punishment for the same conduct. And so you need me to move this mic closer. So I should have been watching her in front. But, you know, so we would object to that on constitutional grounds. And then the other challenge was to offense variable 18, which is scored at 15 points. And that's based on the defendant's blood alcohol content at the time of the offense. Again, I think the court has to score the highest number of points for this variable. And if in fact the blood alcohol reading that was tested by the hospital and determined by the hospital to be 0.18 would certainly be deserving of 15 points if it in fact is accurate. We scheduled a Daubert hearing. The court ruled against us in that respect as far as the scientific validity of that reading and moreover the forensic validity of that reading, given that it's not a forensic blood alcohol content. I would ask that be scored lower because I believe there was really no testimony that machine was in good working order. I know there were several people that testified about that machine in terms of generalities, but certainly nothing that would even approach the realm of a forensic blood alcohol content, which is what the law requires people to prove, is that the defendant's forensic blood alcohol content, his legal blood alcohol content was at or above a 0.08. So we would object on the grounds of 15 points, or ask the court to score that at 5 points, given that there is some evidence that there was alcohol consumed prior to driving. Aside from that, Your Honor, notwithstanding the constitutional challenges or the challenges to guidelines, as I indicated, if the defendant were only convicted of one of these felonies, had he only been charged with one of these felonies, certainly the people can sustain multiple convictions. Mr. Hartung has briefed that. We've stipulated that the court can, in fact, and should, in fact, score the defendant the highest number of points that they can sustain a conviction, a concurrent conviction for both reckless driving causing death and operating while intoxicated causing death. So I'm not challenging the court's ability or the court's duty to actually impose a sentence that would be concurrent with each conviction, but rather I'm just trying to point out the fact that were it not for the second felony conviction, and I'm not sure there's really any way to sort of parse out which portion of the defendant's activity or conduct was reckless and which portion was owing to the fact that he was intoxicated. Notwithstanding all that, if he were convicted of one felony here, the prior record variables would have been 0, and the guidelines would have been 1938 months. And so we have, as a result of multiple convictions, notwithstanding the constitutional challenges for essentially the same series of conduct, we have an elevation in the guidelines from 19 to 36 months, 19 to 38 months. We go up to 36 to 71 months. So it almost doubles the guidelines in that respect. I know the recommendation is fair. It's within guidelines. The Department of Corrections is recommending a sentence of 46 months, which would be within the guidelines as scored currently. I'm just simply asking the court to consider a downward variance from the guidelines in light of the inflation in the guidelines, in light of the defendant's acceptance of responsibility, and in light of all the circumstances that surround the defendant's history. Thank you, Your Honor.
Thank you, Mr. O'Keefe. Mr. Hartung?
Your Honor, I received the memorandum on Monday, and I called or got a hold of Mr. Moore shortly thereafter, told him that in case the court wanted to ask him any questions about how he scored the guidelines, he should be prepared. But as it relates to PRV 7 first, the PRV is very clear on the concept that 10 points are scored for one subsequent or concurrent felony conviction. It's very clear. I understand the objection here, but I don't think there's any case law on that issue. But I would point to the analogous case that we talked about a bit at the time of the trial, which is People versus Friedel, which is 340 Mich. Act 221, that in detail outlined the concept that someone could be convicted of both reckless driving causing death and OWI causing death, and frankly manslaughter out of those same factual circumstances. And because of that, I think this is an appropriately scored PRV number for the court to consider. I think Mr. Moore scored that correctly. As it relates to PRV 18, or excuse me, OB 18 rather, we did have an evidentiary hearing. We went through that in some detail. We did it again at the trial. I believe the court ruled correctly and the jury found the defendant guilty of the OWI. There, we had testimony from numerous people that were involved in the taking of that blood: nurses, phlebotomists, runners, blood techs, lab techs. We even had testimony from doctors and a scribe who's now a doctor. And they were very, very comfortable with the idea that this was an accurate number. And the court ruled that it could be admitted into evidence. And the jury was able to read that evidence and to show that his blood alcohol level was 0.18 at the time that it was taken at the hospital there. And I do believe that OB 18 is scored properly as well, Your Honor. I think we comply with all the statutory requirements of getting that information in, both in the evidentiary hearing and the trial. as well as the case law. I believe it's People versus Courts that talks about that in some detail and was noted in our evidentiary brief. Thank you.
Any response, Mr. O'Keefe?
No, Your Honor.
So the court does appreciate the constitutional argument that Mr. O'Keefe has placed on the record, but obviously I do not change law. I only enforce the law as it is written. So with regard to PRV 7, that is not discretionary. The court must score the appropriate point value if the offender was convicted of multiple felony counts or was convicted. In this case, he was convicted of multiple felony counts. That does not result in a mandatory consecutive sentence. So the court in this case must score that, and it is properly scored at 10 points. The objection to OV 18, again, there is no discretion on whether or not the court can score that, and so the court does find that it was properly scored. Of note, there is an interesting case out there involving actually a minor, but in that case, People v. McGee, which is a Court of Appeals unpublished case issued January 13th of 2009, docket number 280534. They said that the court did not err in assessing points of an underage drinker at the time of the offense because MCL 777.481D does not limit the proof for an underage drinker in that case to just scientific measurement. So testimony as well. But we did hold a hearing, and we did have probably half a day or more of testimony from the individuals working in the hospital about the way that blood is taken, sent, tested, chain of custody. So the court does find that it has no discretion, and OV 18 is properly scored. So with your objections on the record, Mr. O'Keefe, I still have to score those, and the court finds that the guideline minimum range is 36 to 71. Notwithstanding your objections, do you agree that that was properly calculated in terms of adding up the numbers?
Yes, Your Honor.
Okay, thank you. Before the court passes sentence, I would ask that you have a seat over here because I believe we have some people who wish to speak.
We do not, Your Honor.
No one
They've
wishes to
indicated
speak.
no one's going to speak.
All right, so Mr. O'Keefe and Mr. Hartung, can you approach over here? Thank you. I just didn't know she. Sure. All right, thank you.
She doesn't want to give you a number.
Okay. All right, so that being said, Mr. Hartung, the recommendation in this case is for a sentence of, back there, 3 years, 10 months to 15 years with credit for 170 days already served. So do the people have anything they wish to place on the record?
Yes, Your Honor, could I use the podium?
Yep, can you guys step over there and let Mr. Hartung use the podium? Thank you.
Your Honor, I'm going to advocate today for a sentence of 54 to 180 months, and I'm going to explain that. But first, I want to thank some people. This case has been going on since May 30th of 2021, and it's been a long, long endeavor to get to the point where we are today. I want to really thank the entire Campbell family for their hanging in there, for one thing, while this was going on. It's taken a long while to get to this point in time, and they've been very cooperative throughout. Karen Campbell wrote an absolutely amazing victims impact statement. I can't say it anywhere near as well as she has put that as to the impact that this has had on her family and the nature of her husband as well. I want to thank Bill Warner. I want to thank Kevin Greca and Keith Thorney for their help from the Sheriff's Department. Also Austin Hall, who is no longer with the Sheriff's Department, but testified during the trial. I'd like to thank all of the people at Sligo Hospital and the EMTs at Riga and Blissfield Fire Department for their assistance and help throughout this matter. doctors, scribes, phlebotomists, med techs, lab techs, runners, nurses, many of whom remembered this incident years after the fact and testified very acutely as to what they recalled and what they did and the impact that this had on them as well as the staff attorney at Toledo Hospital, who did a great job arranging that all to come in. And these people all appeared voluntarily, essentially. So most of them coming from out of state and some of them coming from as far as, I think, Alabama or Florida. I want to thank the people of my staff, Kristen and Sarah, who helped in the courtroom and helped outside the courtroom to keep this going for 3 years. And I want to say some things about David Campbell. I never met him, but through this whole thing, I got to know him pretty well, I feel. And excuse me, he is quite a man. And he's 78 years old at the time of this incident. He's kind of the cool old dude in the neighborhood. Everybody's got that guy. He's the guy who walks his dog, says hello to everybody in the neighborhood, nods hi, how you doing? Always has extra beer in his fridge for a buddy that stops over. Always wears a cool hat. And I kind of got a feeling about him throughout this whole trial from his family, from the pictures, from everything else I got to see. He kind of reminds me of my father. I'll bet he reminds a lot of people of their father and a lot of people about their grandpa. And he was 78 years old at the time that this happened. He had a life expectancy under most actuarial projections of another 9 years. And I want to talk a little bit about the request by the defense and their memorandum for a downward departure from the guidelines. I think it's not appropriate. It's not an appropriate nature in this case to go above the guidelines. It's not appropriate to go below the guidelines. It's appropriate for a sentence within the guidelines. There's some discussion about the defendant taking responsibility from this, and he did initially. Yeah, but as you recall during the testimony, he started to back away from this. And he told some things that weren't true to Mrs. Campbell about how the accident occurred, how about that the vehicle just slipped backwards into the ditch, which wasn't accurate at all. And when she said to him, you know, Bill, your blood alcohol is, you know, pretty high, it's 0.18. What about that? And you remember what he said, what she said he said about that? He said, make them earn it. Make them earn it. Well, the people at Toledo Hospital and the nurses, all the people involved in that, and the lab techs, and all the people we've talked about, did a great job. The court entered that testimony, evidence, the jury considered it. They earned it. We earned the conviction. So the initial 9 years of life likely taken away from him, and that's 108 months. That's way outside the guidelines, and a sentencing outside the guidelines isn't appropriate. It's not proportional under People versus Milborn, the old case, or the newer case, People versus Posey. But I do think that 54 months is half of that 108-month total. And I do think that's a fair number to look at in consideration for the sentence here. The idea that half of his life is gone because of what happened here is an interesting concept to consider. I think it's appropriate from a proportional standpoint. It's appropriate from the standpoint of deterrence, punishment, all the key factors, I think, and it's right in the middle of the guidelines, as it turns out. This is a number that's smack dab right in the middle of the guidelines. So I'm advocating today for 54 to 180 months as a sentence. Thank you.
Thank you, Mr. Hartman. All right, so if you would stand back up at the podium, please. All right, Mr. Badger, you can come stand next to your attorney. Now, I'll start with you, Mr. O'Keefe. Is there anything you'd like to say on behalf of Mr. Badger?
Yes, Your Honor, I just want to remind the court as to why I think there was a recommendation at the lower end of the guidelines. I think the Department of Corrections correctly recognized that my client has served his country. Up until now, he has had no prior criminal convictions whatsoever. The pre-sentence report even indicates that the last time he consumed alcohol was the time of this offense. And so I think at worst case scenario, I think the recommendation should be followed, that being 46 months. I don't believe that there's reason to go above that, but I do think there is reason to go below that. I've stated that earlier. So I would ask the court to sentence Mr. Badger accordingly.
Mr. Badger, is there anything you'd like to say on your own behalf before the court passes sentence?
I'm sorry to the family for what happened. If I could take it back, I would. If I could pick this place, I would. I still have nightmares over it. I dream of it every day, and no matter what you lay on me with the sentence, I'll forever live with this the rest of my life. And I am so sorry. I am terribly sorry to the family. That's all I can say, Your Honor.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. I was trying to put my hands on when I reviewed the statements, because there's so many statements for both sides. There was a statement, I believe by you, Mr. Badger, that was contained. Let's see if I can find it. But I can't put my hands on it, but to summarize, in addition to what you said on the record, you stated that he was your friend. And to this day, you regret your actions and the loss of your friend and that you did that. So the court just wanted to place that on the record as well. So it is a sentence of the court that you will serve a period of 54 months to 15 years with Michigan Department of Corrections. We'll give you credit for time served that was calculated at 170 days. You will pay $68 in state costs for each count and $130 crime victim rights fee. There is a $60 DNA fee. Now you do have, Mr. Moore, is there anything else to add?
So it's 54 to 15 years on each count, correct? And they'll run concurrent?
Yes, I'm sorry. Yes, 54 to 15 on each count.
And then they'll run concurrent, Your Honor?
Yes, may run concurrent, not consecutive. I think the guidelines were the same. Yeah. All right. Anything else, Mr. Moore?
No, I think that's it, Your Honor.
All right. Now, Mr. Badger, you do have the right to appeal this sentence. So bailiff's going to bring down to you your notice of right to appellate review. You need to initial and date a copy that is held separately. Yeah, and that's for my records, just to acknowledge you received the paperwork. The other 2 copies are for you. And if you wish to appeal your sentence, you would fill out the information on the form. You can do it one of 2 ways. You can do it today. You can sit down and do it today, or you can do it at the jail, or you can do it at RGC and get it back to us within 42 days. All right.
I can do it here, Your Honor.
Yep. Have a seat.
Is it possible to get a court-appointed
No,
village lawyer?
we go through that, not today, no,
Yeah.
no. You don't have to do the bottom part, so if you want to have a seat. If you can, I don't know what's easier, but he has to fill out, he doesn't initial and date it, he has to fill out the bottom part.
I'll fill it out later, Your Honor.
No, take your time, you can do it. Now, anything else, Mr. Hartung, Mr. Hartung, or Mr. O'Keefe?
No, thank you, Your Honor.
Thank you.
Your Honor, thank you.
Okay,
My client's acknowledged receipt of the form, Your Honor. I'm handing him, there's 2 copies, so you just need one, or did it go in both out?
I think he fills them both out. I don't know if he's qualified for court appointed counsel because if he has assets from the sale of the home.
Well,
Yeah, so you can, yeah, you can fill that out.
all right,
But you know, you do have assets, so you'll have to fill that in, okay?
okay, thank you, Your Honor.
All right, thank you. And if you do it at the jail, they'll send it over to me in a kite. Records for reflect, I received back a signed copy of the notice of right to appellate review. All right, so Mr. Mont, you got someone standing next to you?
Butler.
Oh, yeah, okay. All right, let's see, I got the jail. I have an arraignment, I believe Rhonda Underwood's on that arraignment.
No.
Hold. Becky, was Benjamin Klein, Miss Adams, was Benjamin Klein adjourned?
No, at this time it is at 3:30 this afternoon.
Oh, I kept trying to figure out why, okay. All right, in the matter of the people of the state of Michigan versus Jonathan Jones, file number 24-21842FH. Rhonda Underwood is on that file and I do not see her, but I also do not see Mr. Jones. Who do I have from the jail?
Casey McKenzie.
All right, Mr. McKenzie, you're also Rhonda Underwood. So just bear with us for a moment, Mr. McKenzie, all right?
All right, thank you.
Okay. What do you have, Mr. Mott? You have Miss Butler, right?
Yes. I'm assuming we'll just set for evidence here.
I don't know. Is Mr. Sala on the other side?
I thought so.
Why don't you come up to the podium? All right, I have somebody logged on as Haley Toms. Are you Scott Toms?
Yes, ma'am.
Okay, this is in the matter of Angela Caitlin Butler versus Scott Toms, file number 2011-36187DP. I have Katerina DeMont appearing on behalf of Miss Butler. Mr. Toms, do you have an attorney?
I was going to ask for a continuance.
Okay, you're asking, and Miss DeMont is probably had stated earlier that she thought we were going to be asking for an evidentiary hearing today to take testimony. So, Mr. Toms, are you going to hire an attorney?
Yes, ma'am. I still haven't received Mrs. Butler's paperwork.
Your Honor, I'm not sure what paperwork he's.
What paperwork are you talking about?
To my knowledge, our last hearing, Mrs. Butler had asked for a continuance because she had not had enough time for a rebuttal.
Your Honor, I filed that. When I spoke with Mr. Sala's staff, they said that they were going to be retained on that. So I proved it to his attorney. I don't have.
Okay, so Ms. DeMont did file a response and talked to Mr. Sala's staff, and Mr. Sala said he was going to be retained. So she had provided a copy to Mr. Sala. So what I'm going to do is, I'm going to, Mr. Toms, are you willing to accept it via email?
Yes, Your Honor.
All right, do you have Mr. Tom's email?
No,
Mr. Toms, what is your email?
That would be henderson495@gmail.com.
So give me the letters. Is it HHEN?
Yes, Your Honor.
So HHENDERSON.
Yes, Your Honor.
And then what was the number?
That would be 495@gmail.com.
All right, so H Henderson, HENDERSON 495@gmail.com.
Yes, Your Honor.
Okay, good. So Ms. Demont will forward to you a copy that she provided, what we thought was your attorney at the time. And Ms. Adams, I need about, well, you can bring me the book, or you can.
Yeah, I'll bring you
try
the
to
book.
find- Okay,
Judge, are we gonna hear my show cause at that time too, when you adjourn it?
yep. All right, because summer break has already started, we need to do this very quickly. So. I can do 1:30, June 27th.
That's
These
good for
have to
me.
be, okay, all right, so 1:30, June 27. And Mr. Toms, I'm assuming you want Zoom?
Yes, Your Honor.
All right, are you available? I have to hear this within so many days, that's like.
yes, Your Honor, I'll
Okay.
figure it out.
You are wonderful. All right, so both of you, thank you so much for working with me on this. So we will see you back here on Thursday, June 27 at 1:30. I'll have you scheduled for 2 hours. Mr. Toms, who are your do you have any witnesses you're going to be calling?
My wife, Haley,
Okay, anybody else?
my younger sister, Alicia.
All right. Anybody else?
I believe that's it.
Okay, and Miss Demont, do you have any witnesses you're gonna be calling?
We would call Miss Butler. And that would be it.
Okay, and their only witness would be Miss Butler or perhaps yourself, all right, sir?
Yes, Your Honor. Could I also include my father-in-law,
Sure.
Larry
What's
Henderson?
his name?
His name is Larry Henderson.
Larry Henderson. All right, are you going to be presenting any documents, Mr. Thomas?
I do not believe so. Everything should already be submitted.
Okay. All right, so Ms. Demont is going to email that to you today. I need you, when you receive that email, to respond received, okay? So that she knows that you received it.
Yes, Your Honor.
Okay, very good. All right, so we will see you back Thursday, June 27th at 1:30 PM. Thank you.
Yes, Your Honor. Thank you.
Thank you both. All right, Ms. Underwood, and okay, so Ms. Underwood, couple things. I have Casey McKenzie. So this is in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 23-21324FH. Mr. McKenzie is represented by Rhonda Underwood. This is a date and time scheduled for a probation violation hearing. Ms. Underwood, how would you like to proceed today on behalf of Mr. McKenzie?
Your Honor, could I just have a very brief, and I stress brief minute with Mr. McKenzie?
Okay, so before I do that though, Ms. Underwood, I'm gonna call in the matter of the people of the state of Michigan versus Jonathan Jones. File number 24-21842FH. Deputy Warning, we do not have MDOC here, correct?
No.
Yeah, so MDOC is neither zoomed in nor appeared today, Ms. Underwood. I don't know if the people did a writ. I don't know if you filed a waiver.
I did not file a waiver, Your Honor.
All right, so we will, Miss Adams, I have the book. So what I'm gonna do is set this over to I'm going to set this over to July. Oh, no. Becky's gone. I'm going to set this over to, not gonna do that either. Hold on, I'll find it. Well, I'm gonna do July 10th for arraignment. July 10th for arraignment, and the people will do a writ and we'll do the notice of hearing. All right.
Ms.
Yes,
Underwood,
Your
did you receive the amended information in this manner? Can you check that for us? And if you didn't get it, oh, excuse me, the one with the supplements on it.
I do not have the one with the supplements on it.
Okay.
Judge, it was emailed to Miss Adams. Someone from our office was supposed to bring copies up here. I see that didn't.
Okay, so no, if you email it to Miss Adams, it doesn't get filed.
Right, I understand it.
So I have a copy of it, but it's gotta be filed.
I understand. We'll get that filed today, but if we could arraign him on that one.
Okay, I'll have it in my file by then, so thank you. All right, so, yeah, all right, so I'll set this over, like I said, to July 10 at 8:15 in the morning. And anything else we need to address on that, Ms. Underwood?
Yes, Your Honor, thank you.
Okay, all right, so we'll see you back July 10 at 8:15. Sorry about all the confusion. Thank you all. All right, now I'm gonna open up a breakout room, Mr. McKenzie, and pop you and Miss Underwood into it. Underwood. Okay, there we go. Ooh. Okay, so, Mr. Daly and Miss Arnold, have you had an opportunity to go through the final jury instructions?
Judge, we have one issue. Our next witness is one of Brianna's siblings, and her mother got pulled over for speeding. So we're trying to get them to release her and figure out how far away she is. So we did go over the jury instructions, so.
Okay, but the jury instructions, no objections or anything you
Well,
need to add?
3.3, I've got a note for the court. 3.3, the defendant not testifying, Jim said he is gonna testify, and then 20.13, we had that issue that the word touched wasn't on it. I emailed it to you, Sierra, and Becky, and Sierra said she got it, so we need to substitute that.
So we're taking out the one about defendant not testifying,
Yeah, I've got this, and then we got to substitute 20.13.
and that's been put in there yet? No.
Miss McGrain should have it. I don't, she didn't, I had it with me, so she hasn't put it in there yet.
Do you have it?
I emailed it to.
I thought you said you have it with me. Oh, the book.
Right.
Email it to me. Today you emailed it to me? Oh. I'm gonna print that off, stick it in there. Mr. Daly and Ms. Demont, have you had time, did you need to speak with your client? Has everybody accommodated you on that? Bruce. Right, so I've replaced 20.13. Look. And. Oh, Ms. Underwood, you are back. Let me close that breakout room. All right, so Ms. Underwood, you now had a chance to speak with Mr. McKenzie.
Yes, Your Honor.
All
I
right,
discussed this matter with Mr. McKenzie. Mr. McKenzie has other files open, Your Honor, with Mr. Malero that I believe are scheduled for trial in September. Mr. McKenzie at this time would request a brief adjournment so that we can figure out how best to proceed so that these matters can be resolved successfully, Your Honor.
how long would you like an adjournment?
2 weeks.
Okay, so July 3rd.
That's fine, Your Honor.
Okay, and it's about, so we'll do the notice of hearing. So we'll set this over to July 3rd at 8:30 in the morning. And we'll see you back on that day, Mr. McKenzie. All right, I'll continue your not guilty plea.
Thank you, Your Honor.
Oh, Mr. McKenzie, you are muted. So why don't you unmute your device?
Is that good?
Yeah, what were you saying? You were saying something.
I've been in jail since January 3rd. I have a home invasion and 3 felony firearm possessions. I've been to court downstairs about 5 times. I've stressed the issue every time I've wanted a trial within 180 days. And if I gave up my right at any time that I was ill advised by my lawyer, I wanted it in 180 days. I didn't have my proven for almost 100 days because they kept messing up on my writ from another county jail. My lawyer won't come see me. I let him waive arraignment in circuit court.
So, Mr. McKenzie, the only thing I have this morning is this violation of probation. I don't have your other files. I don't have the attorney or a prosecutor present on it. So I'm gonna set this over for 2 weeks, okay?
So who do I talk to? Because my next court date for that's not till September 22nd. And I can't get a hold of my lawyer and he won't come see me. So that's the problem.
Ms. Underwood will send a note to your attorney that you want to speak with them. All right?
All right.
All right. Thank you, Mr.
Thank you, Your
McKenzie.
Yeah.
Thank you.
No.
Judge, are you doing this car at another time?
Am I doing what?
Aaron Carr was picked up.
I don't have time to do my pickups this morning. I'll probably try to do them this afternoon or after my jury goes into deliberations.
Okay,
Is
will you
that-
just text? Will you
Is
just
that
text
the
me?
case with Hannah Walt as well, Your Honor?
Yeah, I have to get back to my trial. So Hannah Walt and Carr will be sometime today, but I don't know when.
All right, you'll text me.
All right. We'll let
Thank
you
you,
guys know.
Bob.
Thanks. Bye.